Hey all, welcome back. This is a little share. It's actually an extraction from the longer format of the live Q&A recently. And I thought this question and answer might be generally helpful for some people. I'll try to have it kind of defined in the title so that you're only clicking on it if it's something that will be useful to you in your claim or your post-claim activity with the SSA with regard to other Social Security disability, SSI, dependent benefits, or retirement benefits, or anything else that could touch on the Social Security world that we all swim in right now. So I hope it helps, and I will talk to you later. If you ever want to be there live, that would be Wednesday, 1 p.m. Eastern Standard Time. We have the usually about 2 hours Q&A session, so anybody can ask their Social Security questions if they so desire. Okay, I will see you then. Bye, guys. George just got released from PT after 6 spine surgery. George, ouch. I asked my therapist, do they ever do a RFC for SSA? They said, no. Is this normal? Yes, most providers aren't going to do squat. They don't want to be, they don't know the SSA rules. And if they say something that's true in their mind about how limited you are, but that doesn't meet the tight threshold that you might have if you're 49 or 52 or whatever of what you need to have it say, now they just sunk your ship by being honest because, and they don't want to be that person. I don't blame them. They don't know the rules. And of course they're going to be honest anyway, even if they did know the rules. The function PT records, the reason why I love them is because they almost give an RFC without giving an RFC. When they talk about, he said he was very sore after last session, said he had bad sleep due to pain after last session, or it'll say having difficulty with this session, needs cueing on posture, still needs more. So there's all these little tidbits of information sometimes in PT records that I think are good. There are those little tiny crumbs, guys. It's like a bunch of crumbs to make up that cake to get to an award. And that's why I like PT, because you have, say, 12 visits in 1 month or 2 months. That would have taken you 5 years or 8 years to get that with a specialist. And yes, physical therapist is not an MD, but they were usually referred by an MD, and they can be worth their weight in gold. They're not the diagnosing person, they're not the MD, but they're credible observationists. They're observing you and commenting, and they're not like your family members who supposedly have an incentive for you to win of a financial nature or an emotional nature. So you just saw a little clip from one of our live Q&As. It might leave you more questions, particularly if you had a little piece of that applied to you and some more facts that would make things different. If you do, feel free to put a comment down below about the extra details, and we could maybe even make a video on the particular aspects of that you'd be interested in. So in any event, I hope to see you on Wednesdays, 1 p.m. Eastern Standard Time, and also 9 a.m. every day. We have a share from the field, so to speak, of things that happen in our workday. So hope to see you then, and I will talk to you later. Bye-bye. Hey, so if the subject matter of the video you just listened to is of interest and you want more on it, stay tuned. Here's another one about the same topic, but a little bit different. Bye now. Good afternoon. I was going to address a question that I get a lot, and even online, I see it all the time. Particularly for a pro se person, should you be asking your doctor for a letter to the SSA? I really think it's kind of, it has a lot of risk to it, all right? If your doctor's recordings in your medical records are really thorough and address not just your diagnoses, but the things that are going on with you in terms of symptoms and limitations at home and all that kind of stuff, then there really wouldn't really be a need for a letter. And the bigger reason, though, is that if a doctor wants to send a letter, off the cuff about you, trying to help you, obviously thinks you have, some sort of disability or limitations or whatever, what we tend to often see is a well-meaning doctor will include some verbiage that he or she does not realize is indicative of not falling on the side of disabled under the SSA policy rules. So they might say, Don can only, I don't expect him to be able to stand or walk more than 4 hours in an 8-hour day. Well, guess what? For many, many people, given their vocational profile or work history and everything else that goes into a decision as to whether you can do your old work, either as you performed it or as it's generally performing in the economy, or any other of the 12,000 jobs out there or more, according to SSA. So if saying, the doctor's thinking 4 hours out of 8 is all he can walk, when a regular person can walk from, morning till night, an unimpaired person, that's significant limitation. And it is. However, it does not necessarily eliminate all jobs from being performed, particularly some sit-down jobs, for instance. So them saying that could actually be the nail in the coffin of your case in a bad way. I mean, you won't be able to be found disabled potentially, depending on what your vocational profile is. So if your doctor isn't aware of that, and he is maybe not, you believe you can't even be on your feet 4 hours. So now he's thinking that's a lot, but he doesn't actually know what you do at home and how limited you are. All of this can really be worked against you. So I really kind of implore people to not just ask your doctor who is not well versed in Social Security laws, and there's a ton of them they would have to know, and all of vocational principles. So asking them to do a letter off the cuff oftentimes can be more hurtful than not, particularly if, and then other times the letter just, people get a letter off the cuff and the doctor just confirms their diagnosis and how long they've been treating them. Well, that's evident from the records already, because diagnosis is always in there. He has to have it in order to get insurance payments and everything else. And the dates of treatment are always in there. So it's not necessarily going to be helpful to you. I know it makes you maybe feel like it's going to be bettering your case, but a lot of times, like I said, something very limiting that the doctor thinks it's extremely limiting, but the doctor doesn't understand that that limitation actually works with certain jobs, he can be really hurting your case. So we do ask for medical source statements, and that's what we refer to them as. But when we do them, they're after the plethora of hopeful medical evidence is in, including from that doctor and all the other doctors. And if there is something that the doctor might be willing to confirm that is not really clear from his records, but it's not disputed in his records, because his records have to support his medical source opinion at some point, going down the road. So when you get that letter in. So if his letter is not supported by his own records, certainly if it's not supported by other records, and if, gosh forbid, it's inconsistent with other medical evidence in the record, it's not going to be well taken, and it might just be utterly disregarded. And then there's a risk also of, if they find the doctor lacking in credibility because of this letter, will they also then find his records to not be something to rely upon a lot when making a decision as to how limited you are. So there's a variety of risks. And when we want to get a statement from a doctor, I usually like the doctor to know a little bit about the law that he's referring to. So we have a little guidance page where he can know what certain definitions mean, so that he's not just speaking off the cuff and using language that means not disabled for you. Okay. So we try to make it clear that this word is going to mean that you can do this 2/3 of a workday. This word means only 1/3 of a workday, So without giving him some kind of narrowly defined a question, so that he's not answering questions on things he doesn't even treat you for, or if the answer he's going to give, because it's accurate, is not one that's going to help your case, I don't want to ask him that question. I want to ask him the very limited questions that would be where the answers we know support disabled, what we know to exist from the rest of the file and from you supports disabled, and can't really be twisted in a way that would otherwise be able to hurt you. So it's kind of like threading a little needle. We don't want to give the doctor, sometimes people throw out these 9-page requests for, it's like an RFC questionnaire that you can get online. And the doctors are just going to say no anyway. And then if they do answer it, they could be answering about, can she use foot pedals? And they have no idea, because they treat you for your arm and they're trying to be helpful. So they answer something and it's contradictory to the other evidence. And now credibility is shot. So it's really something you got to be really careful with. I think it's got to be done individually based on your records, and the records have to therefore be full. So you're not really, it's not something you're really necessarily going to do in the first few months of an application. And I'll go even further to say most doctors won't even do them, you know, but there are some that are definitely caring about their patients and know the patient is seriously screwed up and will do them. So they're worth their weight in gold. Some will also charge you, some won't charge you. Some that charge you will be reasonable. Some that charge you will be far from reasonable. Because really what you're just asking them, you don't want them to evaluate you and give you an exam. They've been doing that every time you visit them. We're asking them for their opinion on their patient that they've been treating. So that is a whole nother issue as to the doctors that won't help their patients by at least providing actual information that they have and that they're paid to have, yet then they're not sharing it. But in terms of the danger of asking a well-meaning doctor for a letter without actually honing in carefully and making sure he knows what things you want to know about, what different definitions are. So if he's going to say someone could do something occasionally, he needs to know what that means. Anyway, that's the answer that I would give when my clients say, should I get a letter from so-and-so? I'm like, no. If there's something specific that can be helpful, we will ask it of him. And it would only be if he's not completely contradicting it already in his records. So, you know, you can't, you give him contradictory or he gives contradictory answers. Now everything that he has said is shot. So, you know, you got to be very careful what you wish for, because you might just get it and that might not be what you wanted. All right. So I suggest no letters, actually, since I don't think you're going to know how to do it. It's not something that happens overnight. And it takes me hours to put it together for a client. So, and that's when I know everything that I know their file and I know the law that needs to be applied, but you're always trying to carefully thread that needle and make sure you're not asking the doctor too many things that he's going to be like, I'm not filling this out. You're asking for 10 pages of stuff. I keep mine to 1 page. And each question is only those that would be relevant to the case. And you're not going to know what's relevant to the case. I don't think you are. It's just not, I haven't seen it yet, actually, in a client ever. All right. I will chat with you later. Bye, guys. Thank you for joining and taking a listen to this video. If you have any questions that relate to this or anything else with regard to Social Security, disability, retirement, SSI, etc., please do feel free to post it in the comments below, even if it's not necessarily related to this video. And I will see them. And if it's something I can do a video on, I will be happy to do that. If you are looking for representation in a current battle to prove that you are disabled, whether you have applied yet or not, and ideally, if you have not applied yet, that's when we like to come in and start from the beginning and do our wonders. You can go to joydisability.com, look up to your left, and there's a little link for a free SSD evaluation, and we will take a look at it and let you know one way or the other. If you are looking for a consultation, not representation, or you can't get representation for whatever reason, or it's a non-representational type of issue you need to review, you are more than welcome to order a prepaid consultation. It will be with me personally, and that link is on that same page, joydisability.com, but over on the upper right. Anyway, thanks for staying tuned, and I hope to see you every day, 9 a.m. with our little video shares or live Q&A if you want to join me live on Wednesdays at 1 p.m. Eastern Standard. Thank you so much. Have a great day. Bye-bye.